Here in Arizona, you're committing a felony if you drop off a mail-in ballot for someone who isn't your relative, isn't your housemate, or isn't in your care. On Tuesday, that ballot collection law, you may know it by the pejorative term ballot harvesting, goes before the U.S. Supreme Court. This case pits Arizona Attorney General Mark Brnovich and the Arizona Republican Party against attorneys for the Democratic National Committee, the Arizona Democratic Party, and Secretary of State Katie Hobbs. Also up for review, a policy requiring voters to cast in-person ballots in their assigned precinct. Opponents argue the law and the policy discriminate against minorities and violate federal law. But looming over all that, a broader question. Will the conservative court give us a new interpretation of the laws that protect your right to vote? We're honored to have Scott Bales, a retired Chief Justice of the Arizona Supreme Court, joining us this morning. Justice Bales was part of a team that filed a brief with the court in support of the Democratic National Committee. Justice Bales, welcome to Square Off.
Thank you.
This seems like one of those test cases that tees up an opportunity for the Supreme Court to issue a ruling far more sweeping than this case might demand. In other words, they could go big here, much bigger than this individual case might suggest. Are there signs that the court sees it that way?
Well, it's a very important case for purposes of the Voting Rights Act, perhaps our most important civil rights law. And one issue in the case is how the court will apply the law's prohibition on practices that result in the denial of the right to vote on account of race. So it is a case that will have implications beyond Arizona and have important implications for protecting the right to vote.
So far beyond what the Attorney General will be defending. Now, Attorney General Brnovich says the ballot collection law is, quote, a common sense way to make voting more secure. Do you see any value in limiting who can drop off a mail-in ballot?
Well, in Arizona, if you look at the history of this law, it reflects that it was enacted in an effort to reduce voting, particularly by minority communities. And it was based on unfounded allegations that there was some need to protect against fraud. Arizona's law already prohibited the fraudulent use of mail-in ballots. So the prohibition on third parties delivering ballots for other people wasn't necessary in order to promote integrity in the voting process. And as the Ninth Circuit opinion recognized, what it actually reflected was a desire to make it more difficult for certain communities to cast votes.
And the Ninth Circuit rejected the law. The Supreme Court is hearing the appeal. Now, your brief cites the Attorney General's first and only prosecution under the law, charges filed last December against two women in San Luis, Arizona, on the border near Yuma. Why do you think that prosecution is so significant?
Well, I think it's relevant in two respects. First, it illustrates that this law isn't necessary to protect against some kind of systemic fraud with regard to the collection of ballots. The allegations in the case are that the two women between them possessed 4 ballots and that the ballots were actually delivered as contemplated by the voting process. There's no allegations of fraud in the charges or in the Attorney General's press release regarding the complaint. But second, I think it's important because it shows the danger of this kind of law, that it could be used to discourage voting participation in minority communities. The investigation was conducted in the midst of early voting for the general election, even though the allegations in the complaint relate to the prior primary. And if you have law enforcement going through a community, interrogating people about how they're voting or what the voting practices are, we know from Arizona's history and that in other states that that can have a very chilling effect on the exercise of the right to vote.
Expand on that. You note in your brief that the Yuma County Sheriff's officers were going through homes, to homes, knocking on doors, looking for witnesses in this case?
That was what the group Verified Action that I'm representing along with other lawyers had heard from people in the community, that sheriff's deputies were going out into the community, asking questions. And when information was sought about that, or when there were requests that this practice desist, it was met with silence on the part of the sheriff's office. We learned later that it was evidently an investigation prompted by the Attorney General's office that resulted in this case involving 4 ballots.
And I'll just add, there's a Texas group, a Republican group in Texas, a voter integrity group that's claiming some credit for these indictments. We have not worked through that. Let's turn to where the Biden administration stands on this. The Trump administration sided with Mark Brnovich. The Biden administration's position is a little fuzzy here. Can you help parse it, break it down for us?
Well, the Department of Justice in the last couple of weeks sent a letter to the Supreme Court saying that no longer had the views that were expressed in its earlier brief. It had filed what's called an amicus brief in the case. It wasn't a party, but it submitted its views, as is common. The letter reflects that they no longer adhere to the views stated in that brief, but they also say they're not questioning the statement in the earlier brief that they disagreed with the conclusion that the Ninth Circuit had reached as far as the laws having the resulting in discrimination.
So the Biden administration might side in part with the Trump administration? Is that how we should read that?
Well, I think it's perhaps more accurate to say it disavowed in part what the Trump administration had previously said in its brief.
Okay. Last question. I'm going to ask you to be a legal analyst here on the larger, more far-reaching question we discussed at the top of this interview. What does the record of the justices on this court, particularly the conservative ones, tell you about their feelings about the Voting Rights Act?
Well, the court in the last decade has taken a more restrictive view of the Voting Rights Act. Most significantly in the Shelby County case in 2013, it basically made ineffective the provisions in the act that require pre-clearance, and that's why it's all the more important that Section 2 be interpreted in a way that gives it force, that helps prevent state laws that disparately restrict the right of voters, particularly people of color, to effectively cast their votes.
All right. Justice Scott Bales, thank you so much for joining us.